I'm Eric Frumin, Health and Safety Coordinator for Change to Win. I've worked in this field for 36 years. We greatly appreciate the leadership of Chairman Miller, Ms. Woolsey, the subcommittee for holding this hearing and for your determined interest in the serious problems confronting workers, ethical employers, OSHA, and others concerned with the severe gaps in OSHA's enforcement, including specifically the question of outdated penalties. These shortcomings endanger workers' lives, and Congress has the power to close the gaps and strengthen the protections that workers deserve. We strongly support the Protecting America's Workers Act. We also support the other changes that we now understand the committee is considering to further improve the bill. And I would note that the AFL-CIO has submitted a statement of support as well. First, let's recognize that the OSHA Act has made substantial difference for workers and employers, but 40 years on, the OSHA's enforcement program is too weak in many respects. OSHA's ability to effectively conduct enforcement programs has been diminished, and even with the important additional resources which President Obama and Secretary Solis have added, the number of inspectors has still not kept pace with the growth of the workforce. Many of the deficiencies in enforcement rest with the Act itself and must be addressed through congressional action. The maximum and minimum penalties are too small to deter misconduct, particularly in comparison with environmental and other safety laws. OSHA continues to find and cite repeated violations where employers don't even fix the violations for which OSHA had cited them before. Why should negligent managers feel free to engage in such negligence in the first place? Stronger sanctions are clearly necessary to make them fix these dangerous conditions the first time without waiting for workers to suffer injury. And the problem of recidivist behavior is not limited to smaller employers. Major employers like BP have just paid tens of millions of dollars for failing to keep their promises to their employees, their shareholders, and their communities, not to mention OSHA. In 2005, OSHA cited the Cintas Corporation with a $2,000 penalty for failing to guard machinery, which was very dangerous and which was the subject of a very near-fatal incident the year before. Shortly thereafter, Eleazar Torres Gomez died at a Cintas plant in Oklahoma, and another Cintas employee from Yakima, Washington, Ms. McMorris Rogers, close to your district, was very severely injured at around the same time. After multiple worker complaints, OSHA inspections, and a $3 million penalty, Cintas finally agreed to fix the same hazards in 106 locations in 36 states around the country. It should not have required his death in order for Cintas to accept its responsibilities to its employees and fix those problems after being cited the first time, especially when they knew how serious that problem was. The current penalties are much too low. The message to employers and workers and their communities and shareholders is pretty clear. Workers' lives don't mean much, and corporate executives have little to fear from the Secretary of Labor under current law. In other cases, large companies like Xcel Energy Incorporated hire others to do hazardous work because they know the work is dangerous. For instance, Xcel recently allowed a very disreputable contractor with a history of OSHA violations to work in a very dangerous situation, and led to an incident where 5 employees died. Under the current OSHA statute, huge companies like Xcel who hire these disreputable contractors are exempt from liability. And this is the indictment that the U.S. Attorney secured against Xcel, and in this case they did it for, they indicted Xcel for aiding and abetting that contractor. I'd like to have this entered into the record. But the corporate executives
Without objection.
Thank you. The corporate executives at Xcel fear no more than the ones at Cintas that they will lose their freedom. They are not subject to the penalties, to the criminal sanctions under the current regime. It's time to fix these disparities once and for all between the OSHA Act and the environmental statutes, and we need to address the state plan problems as well. The recent example in Wyoming shows that the states are simply not going to fix these problems and address the penalty structures, penalty weaknesses. Finally, I'd just like to close by responding to one of the things that Mr. Snare says in his testimony. He said that the effort to change the OSHA Act is driven by a few outlier employers. Is Cintas an outlier employer? They're the industry leader. Is McWane an outlier employer? They're the industry leader. Is BP or XL an outlier employer? They're major members of the Chamber of Commerce, and their conduct is reprehensible. We're not dealing with outlier employers. We're dealing with a law and a legal regimen which is simply not up to the task of dealing with and preventing these kinds of outrageous abuses by major American corporations. Thank you very much. I'd like my full statement entered into the record.